Lords. On the point that we were just finishing on, whether my client can make anything of the fact of the requirement of beneficial receipt, it was something we had given thought to before and didn't run with. And having gone round the boy again, I think we have come back to where we were. The way we see it is this, that if taking a very simple example, if a bank has a credit has an account which is in credit, and a fraudster procures a payment to be made into that bank account in breach of trust, the claimant may have a proprietary claim against the defendant to the funds in the account, but will not, on the authority we've been looking at, have a claim in name receipt against the bank, because the bank, simply by reflecting a credit in its customer's account, is not receiving money beneficially itself. We don't think that can be...
I mean, it is receiving money beneficially itself,
yeah,
in the sense that it's the bank's money, and the bank lends money to the customer.
This is true. But I think just in terms of the parameters of the argument we're having, I think in all conscience, all we can say is that accepting the principle that for a claim in name receipt there has to be beneficial receipt by the recipient, all that set of circumstances demonstrates is that a proprietary claim might be brought against a fraudster in circumstances where a claim in name receipt would not succeed against a bank. I don't think I can invoke that as proof that a proprietary entitlement isn't required for a claim in knowing receipt. I mean, I'd love to, but I don't actually think that the logic of that works. All it does is to demonstrate that on the same facts, a proprietary claim might succeed against the fraudster, but a claim in knowing receipt may not succeed against the bank. So, as I say, we can't persuade ourselves to sort of reverse engineer out of those circumstances a positive assertion that a proprietary entitlement isn't a requirement for knowing receipt. That is obviously our case, but I don't think that proves it. We've got quite a lot of case law to get through. You've already got essentially the architecture of what we say the claim's all about, so I hope you will excuse us if we rattle through relatively quickly. If I overrun a little at all, obviously I will have to shave that off any right of reply. But I will certainly aim to be sitting down at 3:30. But there are quite a few cases that have been cited, and I think it will help just to turn at least a few passages over as we go through. So the first one we get to this afternoon is El Ajou, which is it starts at page 1124 at first instance, and we track Mr. Justice Millett's judicial career throughout this whole area of the law, from first instance through the Court of Appeal to the House of Lords. And here we are at first instance, dealing with a case involving an investment manager in Geneva who is bribed by Canadians to divert the plaintiff's money into various fraudulent schemes, some of which passes through, I think, Geneva, Panama, Geneva again, and ends up back in London. In a property development promoted by Dollar Land Holdings in Battersea. And the claim is brought in what was described as common law tracing and knowing receipt. And the knowledge that was alleged was of two individuals, a Mr. Ferdman and a Mr. Stern. The claim in tracing failed. The common law tracing failed because the funds had been mixed with other monies, and common law can't do anything about that. The claim in knowing receipt failed because the trial judge, Mr. Justice Millett, held that Mr. Stern was an honest man, and Mr. Ferdman, who was the other person whose knowledge was said to be attributed to Dollar Land Holdings, Mr. Ferdman did have guilty knowledge, but that guilty knowledge couldn't be attributed to Dollar Land Holdings. So the reasons we just want to take you to it are, first of all, because it is another case involving a misappropriation of corporate assets, not of trust assets as such. The second point is that we do get from this case, albeit obiter, we think, a recognition that a court of equity will exercise its in personam jurisdiction against a person within its jurisdiction in relation to property, even including real property, which happens to be situate overseas. The fact that a person is subject to the equitable jurisdiction of the court here, if he's amenable to the jurisdiction, the court can tell that person what he's meant to do with property overseas, even though the property ownership rights in that property overseas may be governed clearly by the law of the jurisdiction where the property is. And the third reason why we want to take you to it is that the judge did not accept the argument that the claim in that the claim in knowing receipt would fail because the money had passed through jurisdictions in which there was no recognition of the equitable legal divide. So the money had passed through common law civil law jurisdictions, Switzerland and Panama, and that of itself didn't defeat the claim. So if we can just quickly turn to page 1141. Excuse me. Page 1141, F to G, we get the two issues. Counsel for DLH submitted one, that the plaintiff has not established that the money which reached the relevant account, the Kerristal number 2 account back in England, represented the money which was last seen leaving Gibraltar for Panama on the various earlier dates. So it was an evidential question. Did the money that ended up in the account here, in respect of which the known receipt claim, did it in fact represent the proceeds of the relevant breach of duty? 2, that the equitable remedy depends on the continuing subsistence of the claimant's equitable title and cannot be invoked where the money is transferred to recipients in civil law jurisdictions like Switzerland and Panama, which do not recognise the trust concept or the notion of equitable ownership. I reject both submissions. So the first question is the factual one. Could the money be identified, the money in the Kerristal 2 account, which was the account in respect to which the known receipt claim was being made, could it be identified as representing the proceeds of the relevant fraud? And the answer to that was just yes. That's an evidential question. But on the more significant question for our purposes, number 2 in that list, can we look at page 1143? Halfway down the page, the heading, Tracing Through Civil Law Jurisdictions. And he says, first of all, in letters between letters E and G, there's no evidence of foreign law, so the point wasn't open. So I acknowledge what follows is obiter. But what he says at G, even if the argument were open to DLH, Dollar Land Holdings, I would reject it. In my judgment, it's misconceived. For technical reasons, the plaintiff's claim is brought in equity, where it is of a kind generally described as a case of knowing receipt. This is the counterpart in equity of the common law action for money hadn't received. Both can be classified as receipt-based restitutionary claims. Now, passing over the language, what he doesn't say is that it is a claim to vindicate a proprietary ownership right. It's receipt-based, not ownership-based. The law governing such claims is the law of the country where the defendant received the money. Whatever money or property DLH received was received by it in England, and accordingly the plaintiff's claim falls to be governed by English law. And then the last 2 lines of the page says, although equitable rights may found proprietary as well as personal claims, it has long been settled that they are classified as personal rights for the purpose of private international law. And we get a passage here from Lord Selborne and Ewing and Orion, which is quoted in subsequent cases. The courts of equity in England are and always have been courts of conscience, operating in personam and not in rem. and in the exercise of this personal jurisdiction, they have always been accustomed to compel the performance of contracts and trusts as to subjects which were not either locally or ratione domicilii within their jurisdiction. They have done so as to land in Scotland, in Ireland, in the colonies, in foreign countries. So what the judge is saying is that if you have a defendant who is amenable to the equitable jurisdiction of the court, it's the court's function, the way equity works, is in personam against the conscience of that person who is subject to the jurisdiction of the court. And the fact that his conscience may be affected in relation to property which happens to be located overseas and may be governed by the law overseas doesn't alter the fact that equity can operate in relation to his conscience. And so between C and D, the next paragraph, DLH is therefore answerable to the court's equitable jurisdiction as regards assets situated abroad, even in a civil law country. I would urge on you the whole of that page, but if I could just, in the interests of time, excuse me, just read the passage from Lord Brougham in Lord Portarlington, G. In truth, nothing could be more unfounded than the doubts of the jurisdiction. That is grounded, like all other jurisdiction of the court, not upon any pretension to the exercise of judicial and administrative rights abroad, but on the circumstance of the person of the party on whom this order is made being within the power of the court. So that is the difference between equity operating in personam against the conscience of a person within its jurisdiction on the one hand, which it does, and an English court exercising a jurisdiction it doesn't have to declare property rights in relation to foreign property. Clearly, the English court doesn't say, under French real property law, X owns this property rather than Y. But what the English court can say, if Y is within the jurisdiction, is that Y has to account to X for the value of that property. And then at H, an English court of equity will compel a defendant who is within the jurisdiction to treat assets in his hands as trust assets if, having regard to their history and his state of knowledge, it would be unconscionable for them to treat him, for him to treat them as his own. And that is critical, because it's not saying equity will require a defendant to treat assets as trust assets because they are trust assets, because they depend upon beneficial ownership in the claimant. The court is clearly saying that the assets are treated as are ordered to be treated as if they were trust assets because of their history and the state of knowledge of the defendant. And that, in our submission, is critical to...
And those are the assets once they are in the hands of the recipient.
Yes, exactly so. Exactly so.
So the fiction relates to what happens once it's with the recipient. The fiction doesn't have to go back and say, we're assuming you're a trustee, and therefore we are treating the assets when they were in the hands of the company as trust assets.
No, exactly. Exactly. And at the top of 1145, the plaintiff seeks a personal remedy based on knowing receipt. And we do emphasize, I know it's a very, very simple point, but it is worth emphasizing it's a personal remedy, it's not a proprietary claim. So I previously pointed out this is the counterpart in equity, the common law claim for money hadn't received. The latter, at least, is a receipt-based claim, not, I interpose, a proprietary claim, to restitution, and the cause of action is complete when the money is received, not on the basis of ownership. So in my judgment, judgment is the former. That's unless arbitrary and anomalous distinctions are in the common law and equitable claims are to be insisted upon. And then I think that's all we need from that. If I could move on to...
I mean, it's fair to say that he's looking at this through an unjust enrichment lens,
Yes.
I believe.
Well, he's certainly looking through it, looking at it through a lens that is, in his words, aligning unjust enrichment with knowing receipt. I'm not sure he's looking at it as unjust enrichment. I think he's suggesting that the two should be aligned. I agree.
Yeah, it's just that all, the cases that he uses, I mean, if you go back to the citation he gave us at 1,143, the very claim that he seems to be dealing with is the Dicey and Morris unjust enrichment.
Yeah.
Conflicts of law.
No,
he's dealing with Lipkin, Gorman and Cartnail.
Yep. Absolutely right. So that went to the Court of Appeal, which is at 11:55. And the Court of Appeal altered the outcome because they said Mr. Ferdman's guilty knowledge, however honest Mr. Stern was, Mr. Ferdman's guilty knowledge, for whatever reasons, would be attributed to Dollar Land Holdings. And the 2 points we just want to emphasise from this Court of Appeal judgment, page 1155, is that the question whether money received by Dollar Land Holdings represented the proceeds of the relevant fraud was treated throughout as a question of fact. It was just the evidential question, is the money that's now sitting in the Caristol No. 2 account in fact the proceeds of this fraud? It's not. There is no attempt to analyse any question of beneficial ownership. As we have pointed out, the money having passed through civil law jurisdictions. And what we also get clearly from this is that the requisite guilty knowledge is knowledge of the breach of fiduciary duty, not notice of any prior title to property. And indeed, the constituent elements of a claim in knowing receipt are defined without reference to any need on the part of the claimant to establish a continuing proprietary base. And if we could just pick that up in the report, so going from page 1155 to 1158. We'll see the judgment of Lord Justice North at the very bottom of 1158, where he says of the questions that remain, the most important is whether, for the purposes of establishing a company's liability under the knowing receipt head of constructive trust, the knowledge of one of its directors could be treated as having been the knowledge of the company. That is essentially a question of company law. And he then turns to the facts on the next page, 1159. And we go on to, please, page 1162. Letter E, having recited the facts, in our submission it is significant that what Lord Justice North says at 1162E is, it is clear from the foregoing that the £1 million odd paid to the solicitors represented monies that had been credited to the Caristol No. 2 account. It is also clear that the monies so credited belonged to the Canadians. The Canadians were the fraudsters, not the defrauded El Ajou. Now, again, I absolutely accept that the court was not being specifically asked directly to confront the question that is before you. But it is striking that a Chancery Judge of the experience of Lord Justice North positively says that the money credited belonged to the Canadians. So he cannot have understood that it was a necessary element in a claim for knowing receipt for the claimant to establish that the money belonged to the claimant in later recipients' hands. And then he goes on to say what is in dispute is the judge's finding that they represented monies which the fraudulent agent had sent to Panama from Gibraltar, a fact which had to be established in order that they could be treated as proceeds of the fraud. So, as I say, the question of identifying the money in the account was an evidential question of fact. And then over the page at 1163G, on the footing that the monies credited to the Carousel number 2 account were proceeds of fraud, it becomes necessary to identify the assets received by DLH and the dates when it received them. That's more fact. And then we get on to 1165 knowledge. It having been established that DLH received assets representing proceeds of the fraud, I come to the question of knowledge. By the end of the hearing, there could have been no doubt that Mr. Ferdman himself had the requisite knowledge. The judge said of him, he freely admitted that the persons who were providing the money for the Nine Elms project were the persons who had been behind the fraud in Amsterdam, and that by the 7th of April 86, when he signed the letter to Ulara, he knew or assumed that the money which he would be receiving into the Carousel number 2 account was part of the proceeds of the fraud. So what is relevant in terms of guilty knowledge for knowing receipt is knowledge of the breach of fiduciary duty. It's not notice of a priority of title, which would be a relevant question if it were a proprietary claim. It is knowledge, guilty knowledge, of the fact that the transfer represents represents the proceeds of a fraud. And then we get Lord Justice Hoffman with a much quoted passage at 1170 G. This is a claim to enforce a constructive trust on the basis of knowing receipt. For this purpose, the plaintiff must show, first, a disposal of his assets in breach of fiduciary duty; secondly, the beneficial receipt by the defendant of the assets which are traceable as representing the assets of the plaintiff; and thirdly, knowledge on the part of the defendant that the assets he received are traceable to a breach of fiduciary duty.
And by traceable, he must mean in this context traceable in equity.
Well, identifiable.
Well, there was no tracing, as I understand it, tracing in law had been warned off because of the mixing of the money.
So it was the evidential question: was the money in the Carousel number 2 account, did it represent the proceeds of fraud? So that's Elajou in the Court of Appeal, and we see that formulation by Lord Justice Hoffman repeated many, many times subsequently. My learned friends have cited Lord Neuberger in the Court of Final Appeal in Hong Kong, saying that even coming from Lord Hoffman, the words should not be treated as a comprehensive definition, and that Lord Neuberger did not then go on to find any faults with it, or say anything was missing from it, and indeed he went on to apply it. So one then gets to the critical case of Macmillan at first instance, and we have got now to December 1993, and this again is Mr. Justice Millett, and you will, I imagine, be aware that the case arose in circumstances where Macmillan owned shares in a company called Berlitz. The shares in Berlitz were transferred to Bishopsgate, and Bishopsgate then used them as security for various loans from banks. Macmillan then sought to recover the shares, and the banks claimed priority. We would simply observe here that in the Court of Appeal judgment from which we are appealing, the Court of Appeal plunged straight into a consideration of Macmillan, treating it as a case of knowing receipt, without, in our submission, considering its antecedents, and without, in fact, any reliable basis for considering it to be a case of knowing receipt. The passages in the Court of Appeal judgment, the passages from Macmillan on which the Court of Appeal relied, in fact all appear under the heading of choice of law. What was happening in the Macmillan case the main thread with which we are concerned, is that there was a dispute between Macmillan and the banks as to the correct characterisation of the claim for the purposes of choice of law. The banks were saying this is a proprietary claim, and Macmillan was saying, well, it's actually a claim based on an obligation to give restitution. And each of them were offering those competing characterizations in order to suit their claims as to the applicable law. Mr. Justice Millett decided that the relevant question for the purpose of choosing law, the applicable law, was not the correct characterization of the substantive cause of action, but to identify the correct classification of the issue that was actually in dispute between the parties. So what he did was to say, well, actually what is being disputed is ownership of these shares. That's what Macmillan says it's got. That's what the banks are denying on the basis of their assertion that they were equities darling. Whatever else Mr. Justice Millett was doing, he was not purporting to lay down the constituent elements of any substantive cause of action. He was simply describing what the claim in front of him actually involved by way of a dispute. So our starting point in analysing Macmillan is to say it is just wrong to treat it as if it is defining the constituent elements of any substantive cause of action. But more than that, it is absolutely wrong to treat it as describing the constituent elements of knowing receipt, because it plainly wasn't addressing them. It mentions the words knowing receipt once and once only in a passing remark that certain recent case law had got a bit confused, without mentioning any of the relevant case law. It doesn't mention Barnes and Addy, Montague, Belmont Finance, Salanga Rubber, or Agip Africa, Mr. Justice Millett's own decision on knowing receipt. To hold this case up as authority on the constituent elements of a claim in knowing receipt, in our submission, is just untenable. It is only about the correct characterisation of what the dispute in that case happened to be about, and what the dispute happened to be about was the ownership of the shares in Berlitz. And that is clear. If we could turn the case up, it's page 420. You'll see it went on, by my count, the trial lasted 36 weeks. Now, if we go to page 424, you'll see at letter H, His Lordship in the third line says, the action was brought in order to recover 10.6 million shares of common stock in Berlitz, a company incorporated in New York, from various parties into whose hands they had come and who still retained them. It was a claim to recover the shares. And if we turn over to 425, at letter D, the question for determination now is whether Macmillan retained an interest in the shares superior to that of any of the defendants and is accordingly entitled to the corresponding part of the proceeds of sale. And just below letter E, the legal nature of the dispute is also common to the three actions. In each of them, Macmillan seeks to recover the proceeds of sale of the shares in Berlitz from a defendant which claims to have a security interest, having priority to Macmillan's interest. And just below F, It does say Macmillan seeks both proprietary and personal relief, claiming restitution of the proceeds of sale of the shares and equitable compensation for loss. That is, we submit, my learned friend seeks to rely on that to say, aha, this was a case of knowing receipt. It wasn't. It was simply a case in which some shares had been sold. So the claim to recover the shares was defeated. And Macmillan was just saying, well, all right, if we can't have the shares, we'll have the proceeds of sale, thank you, because we own those.
Well, that's hardly equitable compensation for loss.
Well, my lord,
maybe he's misdescribed it, but can you make that good?
Well, that is, yes, we can, because that is the issue that is then described. If we go to 429. He describes at B where various security interests are taken, because this is all in the context of building up to the choice of law. And he says, one of the questions in the case is whether the issues of priority fall to be resolved, as the defendants contend, in accordance with the law of New York, or, as Macmillan contends, in accordance with English law. And then you'll see, two-thirds of the way down that page, there is the heading choice of law. And if we go over and look at page 430, letter G, having recited the arguments of the two parties as to the correct characterization of the substantive cause of action, he then turns to what he actually addresses as being the thing that he's deciding. He says at G, in my judgment, that argument, the argument on behalf of, I think, Macmillan, is circular. It is manifestly correct to characterize Macmillan's claim as lying in restitution, but that is only the first step in the analysis. In order to ascertain the applicable law under English conflict of laws, it's not sufficient to characterize the nature of the claim. It's necessary to identify the question at issue. The English law of restitution makes a fundamental distinction between the unjust enrichment of the defendant, which is occasioned by depriving the plaintiff of his property, and enrichment which results from a wrong done to the plaintiff by the defendant. In the first category of case, the plaintiff's restitutionary claim is said to have a proprietary base. The enrichment of the defendant is at the expense of the plaintiff and is matched by a corresponding diminution of his assets. The plaintiff brings the claim in order to recover his own property and must succeed, if at all, by virtue of his own title. In the latter class of case, his claim arises from a breach of fiduciary or other obligation on the part of the defendant. The distinction is that drawn by equity between the claim of an equitable owner to recover his property or compensation for the failure to restore it from a person into whose hands it has come, and a claim by a plaintiff in respect of a breach of fiduciary obligation owed to him. In the former case, he relies upon his continuing equitable interest in the property under an express or resulting trust. In the latter, upon an equity between the parties which may, in appropriate circumstances, give rise to a constructive trust. The distinction which is crucial may have been lost sight of in the language of some of the more recent decisions on knowing receipt. That's the only reference to knowing receipt. And he then goes on to say, Macmillan's claim is of the former kind. That is, a claim that they still own the assets, not a claim in constructive trust on the basis that there's been a breach of fiduciary duty. And that's why and where he uses the language which the Court of Appeal in this case latched upon. He says, Macmillan's claim is of the former kind, that is, as I say, ownership. In respect to the Berlitz shares, there was no relationship of any kind between Macmillan and any of the defendants, no equity between them. In the absence of such an equity, any liability of the defendants to restore the shares or the proceeds to Macmillan or to pay compensation for their failure to do so must be based upon Macmillan's continuing equitable ownership of the shares. In the language of restitution, Macmillan's claim must rest upon an undestroyed proprietary base.
But he's including within that a claim for compensation for the failure to restore it. At the top of page 431, isn't it?
Yeah.
Yes.
So he's seeming to say, no matter whether you're seeking to get the property back, i.e. a proprietary claim, or seeking against somebody who's received it compensation for him having disposed of it, they're both the former type of claim. And therefore, they must rely on an undestroyed proprietary base. I quite appreciate that most of the shares in that case were still in the hands of the defendants, or
yes.
actually, I think they'd been sold, but the proceeds were in the hands of the defendants.
Yes, but what he is not saying, indeed, he is positively not saying that the claim is one based on constructive trust resulting from a breach of fiduciary duty and a transfer in breach of fiduciary duty to a knowing recipient. Because that's the second kind of claim that he describes, which he says this isn't. And it becomes even more apparent. Your Lordships may recall that we refer to the epilogue of his judgment. If we just flip forward to that, that's page 455.
Just before you go there, the second part of what he's talking about is a breach of fiduciary duty as between the claimant and the defendant.
Where there's some relevant relationship between them.
Yes.
Yeah,
Yes.
but that's not a knowing receipt claim.
No, that's that.
So he can't have been talking about knowing receipt in the second part of that.
Lord, he's not talking about knowing receipt at all in this case. That is our argument.
Why is he saying the distinction may have been lost sight of in some cases on knowing receipt? Why does the distinction important to keep in mind in the context of knowing receipt?
The honest truth is we have not been able to work out why he threw that line in. But the one thing is that it is the only appearance of the words knowing receipt. And
I'm just trying to see whether one could deduce why he thought it was relevant.
I agree. We have made our best effort. The one thing that one can say with absolute confidence about this case is that none of the authorities on knowing receipt are actually discussed, nor are the constituent elements of knowing receipt.
So your submission is this is a case about an equitable proprietary claim. The comments made about restoring the shares, all their proceeds, that's still arguably talking about a proprietary claim perhaps, or to pay compensation for their failure to do so. That's also a bit puzzling on your analysis, is that right?
The compensation is that if somebody has received property belonging to another person and parted with it and still holds the proceeds of sale, then one has a proprietary claim to the substitute assets. That's just a tracing claim to the substitute assets.
So I'm asking, just as I understood you, the phrase "or to pay compensation for their failure to do so" on page 431, you would, as I understand it, just regard that as an odd thing to be saying, or have I misunderstood? Sorry.
No, it's not an odd thing. It does reflect the fact that, assuming that Macmillan had established a proprietary claim to the shares.
Yes.
If the shares have in fact been sold and the banks are now sitting on the proceeds of the sale, then Macmillan has a proprietary tracing claim to the proceeds of sale.
Yes.
Yeah, but compensation is an additional alternative. You see it again at letter C.
Exactly.
So I think my Lord's question is, how does that fit with your analysis? Because that's something different from a proprietary claim.
He talks about restoring the shares, all their proceeds. Yes. I understand your submission to be that's all covered by a proprietary claim.
Yes.
But it's the phrase that goes on, all to pay compensation for their failure to do so must be based upon. I rather understood you to be indicating that was as puzzling as the reference to knowing receipt.
Lord, if by using those words he is saying anything other than, in a sense, handing over the proceeds of sale, it is in ultimately just a redescription of the same concept.
But if you look at the first new paragraph on 431, Macmillan's claim is of the former kind. That's the one that requires an undestroyed proprietary base.
Yeah.
Because looking at the latter, the second type of claim, there's no equity between them, no relationship of any kind between Macmillan and any of the defendants.
Yes.
Well,
but there would be.
What's the equity here? Between these parties?
The equity that arises in a true claim of knowing receipt is the equity that arises as a result of the recipient knowingly receiving, as a direct consequence of a breach of trust, that he is receiving property in direct consequence of a breach of trust. The equity is in relation to the conscience of the recipient as a result of knowing receipt. That's the equity in knowing receipt, and it was absent in that case because knowing receipt wasn't pleaded. And he says this in terms in the epilogue.
I mean, isn't it puzzling anyway? Because nobody, I don't think, normally refers to liability for knowing receipt as triggering an obligation to pay compensation.
No,
it's always phrased in terms of accounting for the gain. So it is slightly puzzling in any event.
It is. I agree. But if I could just
before you do so, there's one other reference to equitable compensation, which is at page 425, letter between F and G, which I don't think actually helps too much, frankly.
No, that's sorry. Yes, yes, that's right. I think that it repeats the same anomaly. Could I just point to the epilogue quickly and then move on? Otherwise I will run out of time. So the epilogue starts at 455, which consists of a rather heartfelt cry as to how unfortunate it had been that the case was brought on for trial when it wasn't really ready. At 456D, he says the greater part of the oral evidence is directed to establishing whether or not any of the defendants had, quotes, notice of Macmillan's interest at the material time. This was the critical issue in the case. We know from Montague, notice is not the test for knowing receipt. It's knowledge. He could not have said that the critical issue in the case was notice if it had been a case of knowing receipt. And it goes on.
You say that, but in El Ajou, just after Montague's settlement, he again uses notice in a context which probably must have been knowledge, unless he was simply not converted to the McGarry thesis.
Well, if one would have thought between Lord Irvin of Legge, David Oliver, Charles Aldous, Robert Hilliard, Robin Potts, Nicholas Merriman, and Gabriel Moss, and William Prout, somebody might have known what the constituent elements of knowing receipt were. And the cases on knowing receipt are just not discussed, nor are the issues. Breach of fiduciary duty and guilty knowledge just don't feature. And he says at the bottom of 457, there might have been a different outcome if that had been the case. 457H, said what he said about bringing the case on when it wasn't ready. He said there have been two further consequences. Had Macmillan had time to take stock after completion of discovery, it might have put its case against Shearson Lehman very differently. Lehman Brothers always assumed that Verlit's shares formed part of the funds under Bishopsgate's management. Macmillan's attempt to show that it knew, or ought to have known, that they belonged to Maxwell Communications Corporation, or Macmillan, was doomed to failure. Had it realised that its best prospects of success lay in showing that Lehman Brothers knew or ought to have known that the funds in question were pension funds, i.e. held subject to fiduciary obligations, and in arguing that stock borrowing arrangements are not appropriate for a pension fund, and that it is a breach of trust for a pension fund manager to put any significant part of the fund at risk by entering into such arrangements, it would have conducted the case very differently and might reasonably have sought to postpone the hearing of its claim until after the determination of other actions which have been brought by the pension fund trustees. And our submission, that is perfectly clear, taken in combination with the language that's used to describe the issues, the failure to discuss the actual issues that would arise in knowing receipt, the failure to discuss the case law on knowing receipt, and a specific aversion to the possibility that it could have been put differently on the basis of what clearly is knowing receipt. Macmillan cannot be held up as authority on the constituent elements of knowing receipt. So the foundational plank in the Court of Appeal's approach that there has to be an undestroyed proprietary base, in our submission, is just unfounded.
I may be a bit unfair to the late Lord Millett, because at page, in your epilogue, at page 456, when he's talking about notice there, he's talking about the bona fide purchaser, the New York version of the bona fide purchaser doctrine. He's not talking about whether they subsequently had knowledge or anything of that kind. He's talking about whether they can clean off the beneficial title by being equity's darling. So it's a perfectly proper use of notice in that context.
Yes, but it does demonstrate that what he wasn't talking about was knowledge for the purposes of knowing receipt. So that's Macmillan. I'll just mention one thing. I'm not going to go back to it. In the course of his judgment, he refers to a much earlier case of Norris and Chambers, which the Court of Appeal also relies on. Norris and Chambers isn't in the authorities bundle, but the facts of it are apparent from a very condensed recitation by the judge. What had actually happened in that case, and this again demonstrates why Macmillan isn't a case of knowing receipt. What had happened in Norris and Chambers was that a Mr. Sadler had paid a vendor a substantial sum of money towards the purchase of immovable property in Prussia and had then committed suicide, so the purchase didn't go ahead. And the vendor in Prussia then sold the property to a third party, but the vendor kept Mr. Sadler's money, and the administrator of Mr. Sadler's estate brought proceedings in England against the third-party purchaser, saying that the estate of Mr. Sadler had a lien on the property overseas. So it was a claim to a property right in relation to property overseas. Mr. Justice Millett regarded the outcome of that case, namely that no claim could be brought here, as supporting the approach he took. And in our submission, that demonstrates further that he wasn't talking about knowing receipt. He was talking about property ownership rights in relation to property situate overseas. The next case, very quickly, is Boscawen and Bourgeois, which is at page 777. Millan and friends rely on this for a passing remark, again from the same judge, which they say supports the proposition that a continuing proprietary base is required for a claim in knowing receipt. I won't go through the facts, they're a little bit complicated, but it was a claim in subrogation. What had happened was that Abbey National, and so I won't do the facts that to make sense I will, Abbey National had made an advance for the purchase of property. The money was transferred to solicitors who were acting for both the purchaser and Abbey National. The money was transferred from those solicitors to the vendor's solicitor, and it was used to discharge the vendor's mortgage on the property in favour of Halifax. But the purchase then fell through, and various judgment creditors of the vendor obtained a charging order against the property, and they sought an order for sale, and Abbey National claimed that it was entitled by way of subrogation to the rights of Halifax under their now released mortgage to a charge on the proceeds of sale in priority to the judgment creditors. So it was a case of subrogation, not a case about knowing receipt. And it's the case in which there is, in our submission, a good illustration of the dangers of, with the greatest respect, of judges saying too much in addressing issues that aren't in front of them. If we look at 783, which contains the passage on which my learned friends would wish to rely, under the heading tracing and subrogation, he's dealing with an argument on behalf of the appellants. The appellants, he's got to the Court of Appeal now. The submission that the Deputy Judge illegitimately conflated two different causes of action, the equitable tracing claim and the claim to a right of subrogation, betrays a confusion of thought which arises from the admittedly misleading terminologies as traditionally used in the context of equitable claims for restitution. equity lawyers habitually use the expressions the tracing claim and the tracing remedy to describe the proprietary claim, the proprietary remedy, which equity makes available to the beneficial owner who seeks to recover his property in specie from those into whose hands it's come. Tracing properly so called, however, is neither a claim nor a remedy, but a process. Moreover, it's not confined to the case where the plaintiff seeks the proprietary remedy. It is equally necessary where he seeks a personal remedy against the knowing recipient or knowing assistant. It is the process by which the plaintiff traces what has happened to his property, identifies the persons who have handled or received it, and justifies his claim that the money which they handled or received, and if necessary which they still retain, can properly be regarded as representing his property. Now, thus far, I don't think we would have issue, but it's the next sentence on which my learned friend relies. He needs to do this because his claim is based on the retention by him of a beneficial interest in the property which the defendant handled or received. Unless he can prove this, he cannot, in the traditional language of equity, raise an equity against the defendant, or in the modern language of restitution, show that the defendant's unjust enrichment was at his expense. So, on the face of it, I accept that what the judge seems to be saying, that even in relation to a personal claim for knowing receipt, the claimant needs to show that he has a continuing beneficial interest. With respect, A, that was obiter. B, the judge cannot, in fact, have meant what he said. Because if you go back to D, tracing, he says, is not confined to the case where the plaintiff seeks a proprietary remedy. It's equally necessary where he seeks a personal remedy against the knowing recipient or knowing assistant. Tracing is not required in relation to a knowing assistant because you don't have to demonstrate that the knowing assistant has handled anything. You just have to show that he has dishonestly assisted in a breach of trust. So, in the course of giving a peroration about what tracing means, with the greatest respect, even Homer, particularly when giving obiter dicta, may nod. And in our submission, this is a bit of a jumble, and it's a jumble also because it conflates equitable remedies with restitution. As it happens, it may not even be good law anymore. We think it isn't, because, and that's the only other reason we've added the case of Menelao in the supplemental bundle, because this appears to proceed on the basis that for subrogation there has to be a continuing proprietary interest, which the decision in Menelao says there doesn't. So on the face of that sentence, I entirely agree, it's unhelpful to my cause, but I do urge on you, it's obiter. It is plainly not correct insofar as it captures knowing assistance as requiring the establishment of a continuing proprietary interest. And the final point, with respect, is if one just looks, I won't read it, but if you look at the passage at F to G, when he's talking about having listed what a claimant will need to show, he then says, in such case, the defendant will either challenge the plaintiff's claim that the proprietary interest in question represents its property, i.e. he'll challenge the validity of the tracing exercise, or he'll raise a priority dispute. If all else fails, he'll raise the defence of an innocent change of position. The one thing he doesn't say is that the issue that in fact arises in knowing receipt would have to be determined, namely, was there guilty knowledge? So, with the greatest respect, he just, because, and this happens when you have obiter dicta, he wasn't actually addressing his mind specifically to the constituent elements of knowing receipt. Or if he was, to the extent that he was, as I say, it is obiter and not a material on which, with the greatest respect, this court should rely. The next decision, just keeping the chronology going, but trying to move on a little bit more quickly, the next decision chronologically is Royal Brunei Airlines and TAN. I don't propose to go to that. It's in the bundle at 1821, Royal Brunei and TAN. That was the case that, as you may recall, that established that for the purposes of knowing, what was then called knowing assistance, there had to be dishonesty on the part of the assister, though not necessarily on the part of the primary fiduciary. The only reason we mention it is that when we now then get to Macmillan in the Court of Appeal, which happened after Royal Brunei Airlines and TAN, Macmillan in the Court of Appeal did not consider any of the knowing assistance cases, the knowing receipt cases that were also ignored in Macmillan at first instance, but it didn't mention Royal Brunei either. And we simply mention that as part of the context in which it is, we say, continuingly apparent that the Macmillan judgments are not judgments dealing with knowing receipt. So Macmillan in the Court of Appeal, page 459. We go straight to 468, which identifies the issues. 468 at letter B. And you see how the issues are described there, and we say that is entirely consistent with the claim being one properly characterised as a proprietary claim. And we'll go over to page 470. Letter E. It is clear that Macmillan's claims in the present case are to some extent proprietary. Mr. Oliver asserts that they are receipt-based. So he's saying they're not exclusively proprietary. That was the case for Macmillan. But he needs to do more than show that the defendants received the shares. He must also plead, in effect, that they are Macmillan's shares, and the statement of claim does indeed say that. Mr. Justice Millett described this requirement as an undestroyed proprietary base. Now again, you get from that what you get, depending on where your head is when you're reading it. If you have reached the view that knowing receipt necessarily requires a proprietary base, then you say, well, there you go, that proves it. But if you read the case law, the judgment below and this judgment, as being cases in which the courts are identifying the applicable law to a claim to own the shares, then in our submission the correct analysis is that what is being said is that the issue, the relevant issue between the parties, was as to priority of ownership, not as to whether there was a breach of trust, a transfer in breach of trust, and sufficiently guilty knowledge, none of which are discussed. And that becomes perfectly clear when the court breaks down the constituent elements of the dispute. We go to 471. We identify that was characterisation. Stage one was characterisation, and the issue is characterised as ownership. Stage two, page 471. For property issues, the appropriate conflict rule for property issues generally, the general rule, which is subject to acceptance, appears to me to be that issues as to rights of property are determined by the law of the place where the property is. The court is dealing with a property claim, not with personal liability in knowing receipt. We go on to 474. We see the heading shares in particular. So still under the heading of what's the law applying to properties, we've dealt with it generally, and then we deal with the law applying to shares. And if we go on to 477, between A and B, first paragraph, I conclude, says Lord Justice Staunton, I conclude that an issue as to who has title to shares in a company should be decided by the law of the place where the shares are situated. That was the issue that was being decided. It wasn't, can a claim in knowing receipt be established, and what's the applicable law to a claim in knowing receipt?
Sorry, where were you reading from? I just can't find it, sorry.
Up the top.
Sorry, 477, just above letter B.
Thank you very much.
And the same again, Lord Justice Auld, between F and G. The question between the parties to this appeal is who has the better right to ownership of shares in a corporation. Lords, we would urge on you, I won't dwell on it, but at letter 478, F to H, 479, again, just in passing, Lord Justice Auld refers to the receipt-based restitutionary claim that is being pursued there as a newcomer onto the class of cases of English law. That's 479G. With the greatest respect, he can't possibly have been talking about knowing receipt as a newcomer if it finds its origins in Barnes and Addy 100 and some years earlier.
So what was he referring to?
He's referring to what is being described as a restitutionary claim, which is the label that was being used for what was in fact a proprietary claim. And then at 484, at B...
Was a proprietary claim also well established?
Touché. 484, between B and C, I therefore conclude that the shares are in the same position as chattels and that the dispute as to priority of ownership of them shall be determined by the law of New York. And, Lords, I think that is all I have time to deal with in that case. If we can move on then, the next one chronologically we've referred to in our written case is Grupo Torres. I won't go to that, that's page 1413.
Just before you leave it, I mean, it does seem to me that some of the rather puzzling language may be explicable, might it not, because some judges were toying with an unjust enrichment analysis.
Yeah, that's absolutely fair point. And that,
so in a sense, you've got what you're suggesting is your proprietary claim, and then you've got this personal, possible unjust enrichment claim, but what your submission is, it certainly isn't saying much about knowing receipt.
Exactly. I'm grateful. Thank you, yes. Grupo Torres, we mentioned in our case, there was a claim in knowing receipt. In that case, the claim was resisted on the basis that the property had been received in Switzerland, which doesn't recognise constructive trust. It is a judgment in a strikeout, so it doesn't take us that much further forward, but there's a passage at page 1423. I don't have time to go to it, but...
Sorry, 1423.
Thank you. Westdeutsche Landesbank is the next one, which is at page 2040. Again, I don't have time to take you to that, but we only cited it for a short passage, which I would again invite your Lordship's attention to in the judgment of Lord Brown Wilkinson at 2076C to E, where again he articulates the foundational importance of the fact that equity operates on the conscience of the legal owner. And he says that a constructive trust is imposed by reason of his unconscionable conduct. And we would say, not because he holds property which belongs in equity to someone else. The next case chronologically that you will have seen referred to in the judgment below is the case of Lightning. Lightning was the claim to a resulting trust in relation to real property that had been purchased in Scotland, which had been bought by the defendant, allegedly with funds provided by the plaintiff. And the court here, and it was a court that again included Lord Justice Millett, Court of Appeal, the Court of Appeal held that the claim to a resulting trust in relation to real property situated in Scotland could be maintained in the English courts by virtue of English law, and we would particularly urge on the court, and I don't have time to go to it, but pages 416 to 417, where we see again the Orr-Ewing principle established that the court operates on the conscience of a person subject to its jurisdiction, and it doesn't involve the property rights of any foreign jurisdiction for the Court of Equity to give rulings as to what a legal owner of assets abroad ought to do with them. And in our submission, it does provide good support for our approach, that the court here is perfectly capable of telling the Saudi National Bank what it ought to be doing with the shares in this case. Or, sorry, not with the shares, accounting for the value of the shares that it has received. Can I just make sure there's nothing, before I move on, that I do want to read to you from that? There is one short point I should take you to. So at page, the case starts at 414. And if I could just take you to a passage at 417 to give you what we say is our response on this, because this I think has been invoked by the other side. So at 417, in the middle of the page, there's a paragraph beginning, as is pointed out by Lord Justice Millett when sitting at first instance in Macmillan, where a plaintiff invokes the in personam jurisdiction of the English court against a defendant amenable to the jurisdiction, and there is an equity between the parties which the court can enforce, the court will accept jurisdiction and apply English law as the applicable law, even though the suit relates to foreign land. In contrast, if the equity which is asserted does not exist between the parties to the English litigation, for example, where there has been a transfer of the property to a third party with notice of an equity, but the lex situs governing the transfer, but by the lex situs governing the transfer extinguished the plaintiff's equity, the English court could not then give relief against the third party, even though he is within the jurisdiction. Now, what we ask you to take from that is this. And you need to think about, with respect, what the equity the court is talking about. Because it mentions again the fact that that bit of Macmillan is commenting on Norris and Chambers, which was about an assertion in England of a property right in relation to foreign property. So what the court is here, and we entirely accept this principle, what the court is saying here is if the equity that is being asserted in the courts here is a proprietary claim to foreign property, and if under the foreign law there is no property right to assert, then the English court can't do anything about that. The English court can't override Prussian property law. But you have to recognise what the equity is. It says here, if the equity asserted does not exist, then the English court can't do anything about it. That, as I say, we completely accept if you recognise that what it's talking about is cases involving, as Macmillan was and as Norris and Chambers was, if you're talking about cases where the equity that's being asserted is a claim to equitable ownership of the property, which is not what knowing receipt is about. Knowing receipt, the equity is a personal liability to account as if you were a trustee because of your conduct, because your conscience is affected by your receipt of property transferred in breach of trust with sufficient knowledge. So when looking at that passage, in our submission, the reference again to Norris and Chambers is significant because it is apparent that what it's talking about is an equity being extinguished by foreign law if what the equity is a proprietary claim to a foreign law asset. And we can live with that because ours is not a proprietary claim. So that's Lightning. Paragon Finance is next chronologically, which is at page 1800. And the circumstances in which this claim arose was that an action was brought by various mortgage lenders against solicitors who had acted for them in the purchase of various properties on the basis that the solicitors had failed to disclose various sub-sales, onward sales. The claims were originally pleaded in breach of contract and negligence, and then more than 6 years later, the plaintiffs applied to amend their pleadings to allege fraud, conspiracy, and fraudulent breach of trust. So the actual issue was whether the proposed new claims arose out of the same facts or substantially the same facts. And the actual decision was no, they didn't. So permission to amend was refused. The reason it has been brought in is there is again reference, and I won't go to it just for this, there's reference at pages 1808 to 1809 to the ambiguities that have been created by the use of the expression constructive trusts or constructive trustee to describe true trustees, such as trustees de son tort, and those upon whom obligations are imposed by the court because of their unconscionable conduct. And there is a clear statement in our submission that a knowing recipient is not a true trustee, although they may be made liable to account as if they were, and that's 1809 E to G. That's a concept that we see repeated. I don't have, I think, time to take you through that. But we do urge that as an important piece of the analysis. There's also a reference, just for the sake of completion, at page 1813 at letter D to the concept of the constructive trust as being a remedial formula, a catchphrase, so not as a vindication of a proprietary right, we would submit. Brown and Bennett is next, which is page 793. This was one of the cases, I mentioned it very briefly, well, the concept very briefly. Brown and Bennett 793, where you have a company, the company is called Pine Court, which went into administration. Administrative receivership. The administrative receivers sold the business to a company called Oasis, which had been formed by some, but not all, of the former shareholders and directors of Pine Court. Pine Court itself then went into liquidation, and the minority shareholders who had not joined in the new company, Oasis, took an assignment of alleged causes of action against the former directors and company secretary and against the transferee company, Oasis. And the claim was brought on the basis of conspiracy, dishonest assistance, and against Oasis on the basis of knowing receipt. And this is one of the cases where, as I say, the principle was clearly established that one of the requirements for knowing receipt is that the transfer in breach of fiduciary duty the transfer has to be the direct consequence of the breach of fiduciary duty. So the fact that the sale in that case was by administrative receivers defeated the claim. And we say that is an important element in the analysis for the reason I outlined at the very beginning, because it emphasises the fact that the architecture of the claim in knowing receipt is based on a primary breach of fiduciary duty and sufficient knowledge of that breach to make it unconscionable. And one of the important elements that provides the structure and, in a sense, the control mechanism for the cause of action is that the transfer itself has to be the direct consequence of the breach of fiduciary duty. We mention that in our case, I think that this is the Brown and Bennett is one of the many cases that cites the passage from Lord Justice, as he then was, Hoffman's judgment in El Ajou, as identifying the constituent elements, and the important passage in this judgment is, I don't have time to read it, but it's page 798, A to E, describing the Hoffman definition, if I may say, as the paradigm example of the proper expression of the cause of action. And in our submission, that provides a helpful touchstone for what the cause of action actually is all about. It is not the vindication of property rights. It's a personal claim based on those three key elements. The next case chronologically is Trustor and Smallbone. Again, I don't have time to go to that. It's at page 2015. Just to give you some context, the facts were that large sums of money were paid out of the claimant company's bank account, principally to a recipient company called Introcom, which was in this jurisdiction. But the payments were made in compliance with the bank mandate, but in fact without authority of the company's board of directors. And claims are brought against Mr. Smallbone for breach of duty under Swedish law in procuring the payments, and judgment was entered for the claimants for substantial sums, and the defendants argued on appeal that although there was no dispute about the unlawfulness of the misappropriations and the impropriety of the payments and knowledge of the impropriety, the argument was that the receipts by the defendant, that other receipts by the claimant should be taken into account, and that the overall recovery ultimately would be nil. The reason we've cited it is because of a passage in paragraph 62 of the judgment at page 2028, which shows in our submission is again simply an illustration of the fact that the court did not consider that it was relevant to inquire where Mr. Smallbone himself had received the payments which came to him, because it was said that he couldn't be in a better position than the initial recipient in relation to the claim in knowing receipt. And that in our submission is, again, it's another illustration, a bit like the obiter comments in El Ajou at first instance, that the fact that money may have been received in jurisdictions which don't recognise the difference between legal and beneficial ownership does not defeat a claim in knowing receipt. And in our submission that is significant because it demonstrates that a continuing proprietary and undestroyed proprietary base is not a necessary element. Foskett and McCowan is next. Again, we have Lord Millet, as he had become. That's at page, the judgment starts at 1289. It is, in fact, a case involving, it's a paradigm case of a proprietary claim, not a claim in knowing receipt. The reason we cite it is simply to illustrate the difference, first of all, between a proprietary claim and a claim in knowing receipt. A proprietary claim, it is clear from this judgment, a proprietary claim does not involve any resulting or constructive trusts, because the only trust or equity that is being enforced is the beneficial owner's rights under the original trust. And one gets that most clearly from the speech. So if we get that at judgment starts at page 1289. And we get most clearly from Lord Brown Wilkinson's remarks at 1295. Letters from 1295E across to 1296D. His Lordship emphasises that the case does not involve any question of resulting or constructive trusts. The only trusts at issue in a proprietary claim are the express trusts of the purchaser's trust deed, and in our submission that provides a helpful reminder of the difference between the claim, the personal claim in knowing receipt, and the proprietary claim in that particular case, Foskett and McCowan. We also, as I say, we have Lord Millett at 1314. And he gives again his analysis of tracing and following as being a process, not as a remedy. And the passage I think I mentioned in opening when we were discussing briefly the questions, the differences between unjust enrichment and knowing receipt. There's a passage at 1316 between letters E and H, which captures very shortly and with respect succinctly the orthodox view of the difference between those two causes of action. So that's Foskett and McCowan. We then get to BCCI and Akindele, and we'll just spend a few minutes on that because that in our submission is in a sense the clearest exposition of the law as it has so far achieved. It's it starts at page 392. Context was that employees of BCCI had entered into fraudulent arrangements with the defendant. The defendant had invested $10 million through a BCCI subsidiary in acquiring shares in a company called BCCI Holdings on terms that after 2 years they would be sold and he'd get $16 million, as indeed he did. And BCCI then pursued him for the $6 million profit he had made. The first instance judge held that the recipient was honest and that honesty was the test for both knowing receipt and dishonest assistance, so the claim was dismissed at first instance. BCCI appealed, and in the Court of Appeal it was held that the requirement for dishonesty applied to dishonest assistance, but that knowledge of the breach of fiduciary duty was all that was required for knowing receipt. And it's just in that context, if we just see at page 403, again we have letter B. The essential requirements of knowing receipt was stated by Lord Justice Hoffman in Ellershoe, and we get the well-known passage. In the present case, the first two requirements were satisfied in relation to the defendant's receipt of the $16 million paid to him pursuant to the divestiture agreement. There is no mention either of a requirement for or of a finding that the money belonged to BCCI in the recipient's hands. So when we actually do get, unlike Macmillan, when we actually do get the Court of Appeal grappling with a claim which is pleaded and decided on the basis of knowing receipt, there is no mention of any requirement to establish an undestroyed proprietary base.
And this is another company.
Indeed, absolutely. Sorry, yes, I should have started with that point. Exactly so.
So it would be an odd statement to make on your submission.
Odd in that it wouldn't represent the law.
Odd because there would be no equitable starting point anyway.
Well, the company owns its own assets.
Yes.
That much is true. So if a continuing proprietary base were required for knowing receipt, then a claimant in relation to a case involving the misapplication of corporate funds would have to establish that the company still owned the property.
In equity?
In equity, yes, exactly.
Yes.
And there's no hint that that is a requirement in this judgment.
It's because the oddity is that knowing receipt on your approach is a useful tool in the context of corporate wrongdoing, where you're not dealing with a trustee.
Yes.
In the context of pure trust cases, it is merely an addition to a proprietary claim.
Well, it may or it may not be, because of course, I mean, one has been thinking, simply because of the facts of cases like Macmillan, about situations where the trust is, in essentially, a bare trust, a nominee. But you can have a situation where there is trust property which is held subject to a discretionary trust. Now, in a discretionary trust, the beneficiaries don't own the trust assets.
No.
But if there is a transfer in breach of fiduciary duty, then one has, in that situation, to identify, well, on that analysis, what is the equity that's being sought to be enforced? If the true analysis is that the claimant, in knowing receipt, has to establish an undestroyed proprietary base, who is establishing that when a transfer is made out of a discretionary trust in breach of trust? Who's got the undestroyed proprietary base there?
Well, they probably collectively own the beneficial interest, and their claim probably has to be, doesn't it, that the property be restored to the trust fund. So they're making it, even if an individual sues, he's suing on behalf of all the beneficiaries.
That might be a way of squaring it, but what in our submission it illustrates is that the concept of an undestroyed proprietary base is actually a mistaken form, a mistaken test. The thread that runs through transfers in breach of trust, transfers in breach of directors' duties, transfers in breach of obligations of discretionary trustees or of Crown land, is that what's happening is that a transfer is being made in breach of a fiduciary duty in relation to the stewardship of the property. It's not a question of vindicating ownership rights.
Yes, I mean the phrase continuing or undestroyed proprietary base, that was why I was anxious right at the start to be clear that one's talking about an equitable proprietary base.
Yes.
Because we're not talking about legal title continuing in any of these cases.
No, I mean clearly the legal title will be passed.
So the reason why Akindele might be said to be a problem for your opponents is because there is no splitting of legal and equitable title at the start of the story.
Yes.
You haven't got an equitable proprietary starting point. Yeah.
And indeed so. And 408, just to be to try and wrap this up, 408 at letter D, having cited the judgment in Montague, which is described as seminal, Lord Justice North says at 408D, the effect of Sir Robert McGarry's decision, broadly stated, was that in order to establish liability in known receipt, the recipient must have actual knowledge, or the equivalent, that the assets received are traceable to a breach of trust, and that constructive knowledge is not enough. And that, again, in our submission, clearly identifies the importance of the constituent elements being knowledge of the breach of trust, not the subsistence of some equitable proprietary ownership right. And at page 410, we get the in a sense, the punchline, 410E. All that is necessary is that the recipient's state of knowledge should be such as to make it unconscionable for him to retain the benefit of the receipt. It's not unconscionable to retain the property which belongs to someone else. It's unconscionable to retain a benefit. My Lords, the next case that we have addressed in our written case is Arthur, and the Attorney General for the Turks and Caicos Islands. I am conscious.
You're now eating into your reply
time.
time.
My reply. I just wanted very briefly to turn a few more pages and then wrap up. Arthur and the Attorney General for the Turks and Caicos Islands was a case involving a sale of crown land at a significant undervalue, which was then immediately sold onward for a huge profit. The specific issue that actually went to the Privy Council was whether the knowing receipt claim was defeated by the provisions of the registered land ordinance. And the decision is a decision on that. It's principally a question of statutory interpretation. But we get, I could just urge on you, a number of things from it. First, the constituent elements of knowing receipt are again defined by reference to what Lord Justice Hoffman says in Ella Jew. That's paragraph, sorry, I'm not sure I gave you the page. The judgment starts at 717. At paragraph 32, we have Lord Justice Hoffman at Ella Jew again. At paragraph 34, we have a very clear distinction between proprietary remedies as against a knowing recipient and the personal liability to account. So paragraph 34 provides, in our submission, a helpful distinction between those two. And paragraph 36, the distinction is drawn by reference to the applicable test for each remedy. Notice of an equitable interest is the test for the proprietary claim. Knowledge of the breach of fiduciary duty is the test for knowing receipt. And so in our submission, that is a decision that strongly supports our analysis. The Court of Appeal just latched on a passing reference to custodial duties in the judgment. We've explained what we say you get out of that in relation to in our written case. And I don't think I need to add anything to that. The next case I just wanted to mention, you will have seen reference to Williams and the Central Bank of Nigeria case. That was a case, that's at 521. In that case, the plaintiff had paid a sum of money to a solicitor on terms that it wouldn't be released until certain funds were made available to the plaintiff in Nigeria. But the plaintiff, the solicitor then paid the bulk of the money to the Central Bank of Nigeria in London and pocketed $500,000 for themselves. And a claim was brought on the basis of dishonest assistance, known receipt, and tracing. The question that actually arose was whether or not a constructive trustee, a person who is liable to account as a knowing recipient, is a trustee within Section 21 of the Limitation Act, such that the limitation period is extended. And you will have seen the reliance we place in our written case on the clear statements that a knowing recipient is not a true trustee. Now, my learned friends take the point in answer, well, yes, of course that's true in the context of the Limitation Act. That's just a case about the interpretation of the Limitation Act. But in our submission, if you go back and reread the passages in Williams, in light of the arguments that we have developed in our submission, they fall into place not simply as being based on the interpretation of what Section 21 of the Limitation Act says, but on what the actual nature of being held accountable, personally accountable, as a knowing recipient actually involves. And so I would invite you respectfully to have a look again at the passages, particularly in paragraphs 9 and 14. There is just one passage which I should deal with, because again, my learned friend seeks to rely on it heavily, and so I just want him to know what we say about it. So this is the decision starts at 521. And the passage that my learned friend is fond of is at page 540. And it's paragraph 31 in the judgment of Lord Sumption, where he says the essence of a liability to account on the footing of knowing receipt is that the defendant has accepted trust assets knowing that they were transferred to him in breach of trust and that he had no rights to receive them. All of that, we submit, is absolutely correct and clear and supports our case. His possession is therefore at all times wrongful and adverse to the rights of both the true trustees and the beneficiaries. No trust has been reposed in him. He does not have the powers or duties of a trustee, for example, with regard to investment or management. His sole obligation of any practical significance is to restore the assets immediately. Now, the Court of Appeal latched onto that sentence and said, well, that must mean that he's under an obligation to restore them because he doesn't own them. But in our submission, you simply cannot squeeze that meaning out of that sentence, particularly in the context of all the material we have already been through that demonstrates that beneficial ownership on the part of the claimant is not part of the constituent elements of a claim in knowing receipt. All his lordship was simply saying there is that for the purposes of the Limitation Act, you can't treat a knowing recipient as a trustee because no trust has been reposed in him. He doesn't have conferred upon him an obligation to manage the trust property, which a trustee has. His obligation is to give it back. Clearly, that is the case if he's got it. But none of that demonstrates, with the greatest respect, that the Lords, this Court was saying in that case that a continuing proprietary base is a necessary constituent element in a claim for knowing receipt. So, in our submission, that passage doesn't provide any support for the position that the Court of Appeal has taken. The last three cases, I'll just mention them without going to them. This case, as you know, this dispute between SICL in liquidation and Samba, or Saudi National Bank. This is our second trip to the Supreme Court on this. There was Akers and Samba a couple of years ago. That was a case in which the claim had at that stage been pleaded on the basis of Section 127 of the Insolvency Act, and the question was there in fact a disposition within the meaning of 127, in our submission, one cannot prize from the discussion in that case about whether or not there was a disposition anything really of great significance either in our favour or the respondent's favour as to the constituent elements of knowing receipt, because it was not pleaded at the time. The case wasn't struck out in order to give the liquidators an opportunity to amend to allege knowing receipt. In a sense, that's a suggestion that the claim wasn't doomed, but I don't think either side, with the greatest respect, can get anything of value out of Akers and Samba. The other two cases we mention in our case, Akita Holdings and the Attorney General of the Turks and Caicos Islands, that's another transfer of land, of Crown land, sorry, that's at page 693. The specific issue under appeal was whether or not the Crown was entitled to recover only the difference in value between the price paid and the true value of the land. There were just three short propositions we get from that case. First of all, it provides another illustration of a claim in knowing receipt succeeding without any formal trust or trust property as such. Secondly, the constituent elements are taken again from Elajou, Lord Justice Hoffman, and thirdly, again, what is clear is that the knowledge that's required is knowledge of the breach of fiduciary duty, not notice of any prior title. We've mentioned DD growth already. That was the decision in which the clear distinction was drawn between unjust enrichment and knowing receipt, and I don't think we need to go back to it now. The only reason I think it featured in the court below is that there was another reference to the custodial obligations of a constructive trustee in our submission in the overall context of the case law. That the use of that word doesn't add really anything of significance. So, sorry, the last few I had to deal with relatively rapidly, and I appreciate I've bitten just over 10 minutes out of my reply. But I wanted to just get through the cases. We have, as you know, put into our written submissions various observations about registered land. I don't think adding to those orally is going to assist. And unless there are any specific points, I think I have conveyed to you what we wished to convey in opening the appeal.
Mr. Crowe, thank you very much. Mr. Green.
Good afternoon. First, unjust enrichment. I hope I'm not being presumptuous by saying that I hope that has now been put to bed and that it's accepted in this court, that although it's obviously an interesting and important issue, unfortunately it's not an issue which can actually be determined in this particular appeal. Unjust enrichment was not pleaded, as is accepted by the appellants, and as you will see when the pleadings are presented to you. And unjust enrichment does not feature in the permission to appeal application. It's not the ground of appeal which is before you. It's not the issue which is referred to in the statement of facts and issues, and it's simply not open to the appellants in the case before you to run it.
Well, that so as a freestanding claim, it would have been open to argue that knowing receipt should be rationalised on a principle of unjust enrichment. But as I understand it, that isn't the way that it's put against you, so you don't, not something you have to deal with.
Indeed, my Lord, and indeed before the Court of Appeal, the appellants expressly disclaimed any wish to do so. And I think it's right to say that if one looks at Lord Burroughs' restatement, and if one looks at Goffin-Jones and Lewin and several other sources, the general thrust is to regard these as potentially concurrent rights of action, that knowing receipt and unjust enrichment may usefully subsist alongside one another. But what's perfectly clear is that unjust enrichment needs to be pleaded if that's what you want to rely on. Your Lordship, together with Lord Burroughs and Lord Briggs, was in a case called Capital Insurance and Samsundar in the Privy Council, where you made this very, very clear. Not merely that unjust enrichment's ingredients need to be pleaded, but that making the obvious point, as a matter of elementary fairness, that's essential. And as you'll have seen from the Relfo case, it's perfectly possible to plead unjust enrichment in conjunction with knowing receipt. Back in 2012, people had the imagination to do it. The appellants in this case were given a second opportunity, a second bite of the cherry by this court, following Akers and Samba, and they clearly chose not to. And that's the end of it. So far as regards the position in relation to a company, I think I should deal with that now. The fact is this, in relation to a company, one's operating by analogy to the position in relation to a trust. What's happened in English law, what's happened in equity, is that the remedies which are available in relation to breach of fiduciary duty when you're dealing with a trust have been extended to other fiduciary relationships, most particularly the example of a company director. And so, what's happened in the context of knowing receipt, and in the context, I should tell you, of proprietary claims also, is that if you have a director who has acted in breach of fiduciary duty, then the same consequences, all other things being equal, will apply in relation to that breach of fiduciary duty as apply in the case of a trustee. But it's the principles that relate to trustees which are being applied across by way of analogy to the case of the company director. My Lord Briggs pointed out a passage in Belmont Finance which draws attention to this. And that passage contains a particularly important sentence, which I don't think was alighted upon. It's at page 762 of the electronic bundle. So Belmont Finance, page 762. And it's the passage, a limited company is of course not a trustee of its own funds, and it is their beneficial owner, but in consequence of the fiduciary character of their duties, the directors of a limited company are treated as if they were trustees of those funds of the company which are in their hands or under their control. And if they misapply them, they commit a breach of trust. It's by this process of analogy. They're treated as though they were trustees holding trust property. So, if the directors of a company, in breach of their fiduciary duties, misapply the funds of their company so that they come into the hands of some stranger to the trust who receives them with knowledge of the breach, he cannot conscientiously retain those funds against the company unless he has some better equity. And that's the point. It is our point. It's the bona fide purchaser for value without notice point, which my Lord Briggs was taxing my learned friend with this morning. If I may say so, absolutely rightly pressing him on it. And it's the point which applies equally in the case of company directors. Because in the case of a company director who has committed a breach of fiduciary duty, if the property's got into the hands of a third party, the third party can say, I'm a bona fide purchaser for value, without notice. Without notice of what? I'm a bona fide purchaser for value of the legal estate or interest, without notice of your equitable interest in the property.
And
How
what
come?
What is the equitable interest in the property? What is it?
Precisely.
What is it?
What's happening is that the courts are addressing this issue on the footing that there is in effect a severance of legal and equitable title on the occasion of the breach of fiduciary duty It's
creating a fiction that there is such a severance.
Precisely, in order to extend the remedy to companies when it would not otherwise be available.
But depriving it in relation to trust situations, extending it in relation to companies, depriving it in relation to a trustee situation. Because you say it requires a beneficial interest in a trustee situation.
No, my Lord, no, I'm saying that it requires an equitable interest in both situations.
Yes.
In the trust situation, it requires an equitable interest as a matter of principle. Our case, as I will continue to develop. In the company situation, the law having developed by analogy to the trust situation, the property that the director holds is treated as trust property for the purposes of this particular remedy. The director is treated as though he is holding property in respect of which legal and equitable title have been severed, in order to provide a platform for the remedy to be conferred on the company when it would not otherwise be available, because otherwise the company would have no claim at all. There is no potential analogy with knowing receipt if the company has not retained an interest in the property. How does the company retain an interest in the property? It retains an interest in the property because you treat the legal title as severed at the moment of the breach of fiduciary duty, and you say, yes, the legal title went to the third party, but in order to preserve the remedy, we are going to say that the equitable interest was retained by the company so that it can, on the basis of that equitable interest, bring a claim.
Can it bring a proprietary claim?
Well, it can. That's my point.
Yeah.
It's pure analogy. And actually, if you were to apply at this point, it proves too much for my learned friend. Because he has, in order to bring the company director case into the second ingredient of El al-Jus, he's got to show that at least it was trust property before it reached the third party. How do any of these cases get rationalised as knowing receipt cases if they are not rationalised in the first instance as cases where trust property has been misapplied by a fiduciary? The issue between the parties is, and it was put very nicely by the Court of Appeal, does it only matter if it's trust property up to the door of the third party? Or is it important, as the respondents contend, that it remains trust property when it passes over the threshold? And that issue applies equally in relation to a company case.
Well, I can see, I understand that argument, because effectively you're saying that what happens with the trust must, by analogy, happen with this non-trust situation. And you may say, well, that's sufficient for you, for your purposes. I suppose that the trouble that causes is that you are yourself relying on what you've said to be a fiction. And one then opens up to think, well, if it's a fiction, is there actually something else explaining what is going on, rather than the actual transfer of an equitable title? And that's where it opens the door, it seems to me, to Mr. Crowe to say there is something else going on. It can't be equitable interest carrying on, because that's real fiction.
Yes. Perhaps I should not have said fiction in response to Lord Stevens. What is actually happening here is that on the occasion of the breach of fiduciary duty by the director, the legal and equitable title is, if you like, constructively being severed. It's a constructive trust.
It isn't, though, with respect, is it? The company's property is always the legal title. They've still got legal title in the stranger's hands.
Well, my lord, the knowing receipt remedy, which is conferred in all these cases, is conferred on the basis that legal title has passed.
Yeah.
If you're in a situation where legal title hasn't passed, you're not in the territory of knowing receipt.
Right.
Okay. So it's perfectly clear what's going on here, my lord, in my respectful submission, and to work your way from the company cases back to the conclusion in relation to trusts is actually to have the tail wag the dog. Because what's happened here jurisprudentially is that in the company context, the director's breach of fiduciary duty cases have been accorded the same status as trusts cases in order to give remedies to companies where companies would not otherwise enjoy them. And to say, well, because it's been made available to companies in circumstances where the remedy wouldn't be otherwise available to them, therefore that dictates the whole underlying basis of the remedy. When you actually come back and look at it in its original state, when it was a remedy which was provided in relation to trustees, that's honestly to look at it the wrong way around.
Well, that makes perfectly good sense, where you're looking at the fiduciary of someone like a trustee for the purpose of wrongdoing and seeing what should be the remedy for their wrongdoing.
Yes.
But it doesn't make so much sense when you're talking about a property right and you're conjuring a property right out of thin air.
Well, but my lord, it's the same point. It's if a trustee commits a breach of fiduciary duty, then there is a proprietary claim against the third party, so long as the asset is in the third party's hands, and the third party has not taken, under some system of law, which destroys the title of the beneficial title, the equitable interest of the beneficiaries. It's precisely the same situation.
So you say that the analysis you're putting forward is that there is a split of legal and equitable title, even in the company director situation?
There has to be, in order to justify the availability of knowing receipt in such a case, because otherwise the third party would simply be able to say, well, I've taken legal title. Legal title's been transferred to me. What is the basis? What is your standing to claim?
But that's my question.
And the answer is provided by Belmont Finance. The answer is there is an equity. The equity is enjoyed by the company on the basis that the assets are regarded as trust property in the hands of the director who is committed to
What that equity actually is.
But your key point, as you emphasise the word subject to any better equity,
Yes.
is that ultimately it turns into a question of priorities.
It does, because it is unquestionably the case that bona fide purchaser for value without notice is equally a defence in the case of in a knowing receipt case involving company directors, as it is in the case of trustees.
So
That's what the Macmillan case is, in a sense, all about, although it's a foreign form of that doctrine.
Yes.
So even if one were not to accept your proposition that there is actually a split of legal and equitable title, you would say, well, on any basis there is an equity, however we might describe that as being, and that in the hands of the knowing recipient, where title is extinguished, the equity is defeated.
Yes.
However one defines that.
Precisely. And if it was the case that there was no equity to start with, then you don't even get into this discussion. And that's the answer.
It's pinpointing what that equity actually is.
Yes.
I struggle with, but
Yes.
That's the way the law has gone, and it's gone in this direction in breach of fiduciary duty cases by analogy to trustee cases. I mean, that's the way in which, and obviously I'm generalising.
yeah.
Wildly.
And you say the same about Crown property.
Yes. It's all done by analogy, isn't it? Because it's the trustee-beneficiary relationship from which this all starts.
And then how about, in your example of by analogy, in a company situation, what happens if it passes through civil jurisdictions?
That moves on to separate questions, my lord, which I will deal with. I mean, the position in relation to that, as you know, so far as we're concerned, is that property being situated in a civil jurisdiction does not deprive this court or any other English court of jurisdiction to exercise its in personam jurisdiction in relation, as regards the conscience of the third party in relation to that property. It's no part of our case that property being in a civil jurisdiction ipso facto prevents this court considering whether a claim in knowing receipt might lie.
I was considering the situation where the company's property had gone to Saudi Arabia and then come back again.
Yes.
And
you
say then that the equity still survives, is that right?
Well, El Aljou is authority for the proposition that if the assets have been transferred by a fraudster through civil jurisdictions, that does not, as a matter of tracing, prevent you then looking to the third party who's received the assets in this country and saying, well, you've now received assets in this country, you're potentially liable in knowing receipt. But if it's the case that someone has received property, a third party and then a fourth party and a fifth party in a civil jurisdiction in circumstances where title has actually been extinguished, then that's the end of the question, both for proprietary claims and for knowing receipt claims. Yes, that is our case. It has to be our case. It's our case in relation to the third party here. As a last point, as 4 o'clock chimes, can I just say to your lordships that obviously my friend was racing through the authorities, but just before lunch he stopped short in Ajip from the key passage. And can I just refer you to it, please? Obviously, the general tenor of the submissions that you're receiving is there's nothing in the authorities to suggest that the retention of the proprietary interest is of importance. Of course, there is, and I shall come back to that tomorrow. But if you would please go to page 688, letter H. I mean, on page 688, the learned friend took you to the heading knowing assistance. He took you to letters E to F, but he stopped short. Please would you read on? It's G and H through to the top of 689A. H is a passage which we quoted verbatim in paragraph 56 of our case. The basis of liability in the dishonest assistance.
I've got the wrong page. Which page did you say?
688.
688, thank you.
Yes, sorry.
Yes.
688. The basis of liability between, so I'm looking at H,
Yeah.
basis of liability between dishonest assistance cases and knowing receipt cases is fundamentally different. Tracing claims, proprietary claims, tracing claims being the language used in those days, proprietary claims and cases of knowing receipt are both concerned with the rights of priority in relation to property taken by a legal owner for his own benefit. Cases of what we now call dishonest assistance are concerned with the furtherance of fraud. This is not the beginning, it's near the beginning of the lines of authority that one can draw attention to which do proceed on the basis of a property right having to be retained. But this is Mr. Justice Millett, and I know it's Mr. Justice Millett again and again. This is obviously one of his special subjects. It's Mr. Justice
Doesn't
Millett.
always seem to be the same Mr. Justice Millett who appears in the different cases.
Well, look, I mean, if one's going to have someone on one side in this area, with all due respect.
He stands astride the subject like a little colossus.
A colossus, man. he does. I mean, Lord Neuberger said when he was quoting Lord Millett from Paragon Finance in the Williams case, bravura judgments.
Yeah.
They are again and again, and perhaps some of them go off into the realms of obiter sometimes. But the fact is, this is brilliant stuff. And back in 1989, he was making the point, which he then makes over 2 pages in Macmillan, and we'll come back to that shortly. But we would say to your lordships, frankly, on a fair reading of Montague and the passages in Montague that we quote at paragraph 86.2 of our case, it's perfectly clear that Sir Robert McGarry was saying precisely the same. It's not enough that you've taken subject to a property right. It's not enough that you've taken with notice. It's not enough that you're holding property. You've got to show knowledge on top of that. And that's exactly what Lord Brown-Wilkinson said in Westdeutsche. We'll come to that tomorrow. It's perfectly clear what the law is in this area. Perfectly clear. What it's been for 25, 30 years, as stated in case law, as stated in Lord Nichols' landmark article, as stated extrajudicially by Mr. Justice and Lord Justice.
Mr. Green, you've shown us Belmont and you've shown us Adjip. I think your submissions can otherwise await tomorrow. I've got one out there.